Hello, my name is Nduka Njoku. You are welcome to today's lecture.
My name is Nduka Njoku.
Today, we are going to look at the source of the Evidence Act, as well as the scope or the application of the Evidence Act. At the end of this lecture, you'll be able to appreciate the role of the common law as a source of the Evidence Act. Equally, you will be able to appreciate or be able to understand the proceedings to which the Evidence Act applies. I believe that you will find today's topic quite interesting. You are welcome.
Today's topic quite interesting. You are welcome.
Yeah, we are looking at sources and application of the Evidence Act. My name is Nduka Njoku. I hope you find today's lecture interesting. At the end of this lecture, you should be able to identify the sources of the Nigerian law of evidence, determine whether the Evidence Act 2011 is the only source of law of evidence in Nigeria, and explain the relevance of the received common law, doctrines of equity, together with statutes of general application in force in England on the first day of January 1900 as sources of Nigerian law of evidence. Evidence Ordinance of 1943 is actually the primary source of Nigerian law of evidence. The Evidence Ordinance of 1943 came into effect in 1945. This ordinance was predicated on St. James Stephen's Digest of Law of Evidence. St. James Stephen's Digest of Law of Evidence itself was an attempt to codify the common law rules of evidence. Then, the 1943 Evidence Ordinance underwent several amendments and was repealed by the Evidence Act of 2011. Accordingly, the Evidence Act of 2011 is the primary source of the Nigerian law of evidence. Nevertheless, other legislations that are validly enforced in Nigeria may be relied upon for the purpose of supplementing the provisions of the Evidence Act 2011. This is only for the purpose of supplementing, not that those other sources, those other laws that are validly enforced are the primary sources of Nigerian law of evidence. This is only possible by virtue of Section 3 of the Evidence Act 2011. That section provides that nothing in this act shall prejudice the admissibility of any evidence that is made admissible by any other legislation validly enforced in Nigeria. The purport of this section is that it makes it possible for the admission of evidence which is admissible by other legislation that are validly enforced in Nigeria. So if a legislation is validly enforced in Nigeria and it makes rules regarding to admissibility of evidence, that law can be relied to supplement the provisions of the Evidence Act where it is necessary. Then, what are those laws that are validly enforced in Nigeria What are those legislations that are validly enforced in Nigeria? They include the High Court laws of several states in Nigeria. They also include the received common law, doctrines of equity, together with statutes of general application enforced in England on the 1st day of January 1900. The essence of this is that the common law rules, doctrines of equity, together with statutes of general application enforced in England on the 1st of January 1900, which relates to admissibility of evidence, may be relied upon to supplement the provisions of the Evidence Act 2011. Nevertheless, where the Evidence Act 2011 have made specific provisions, where the Evidence Act has made specific provisions relating to the admissibility of evidence, no other law will be applicable. The Evidence Act 2011 will then be the sole authority regulating the admissibility of that specific issue. So, the purpose of these other laws that are validly enforced is to supplement the Evidence Act 2011, where there is a lacuna, where there is no specific provision of the Evidence Act regulating a specific issue. If you look at the case of Aru versus Itule, the question was whether a confessional statement, a part of a confessional statement of an accused, which is favorable to him, can be admissible in evidence. The Supreme Court was of the view that the Repealed Evidence Act did not make specific provision relating to that particular issue, and that reliance may be placed to the common law for purposes of resolving that issue. At the next slide, you'll be expected to provide an answer to the class activity stated in that slide. It says, discuss the role of the Evidence Act, the role of the Evidence Ordinance of 1943 as a source of the Nigerian law of evidence. Let's look at the application of the Evidence Act 2011. Section 256 of the Evidence Act 2011, it says that all judicial proceedings in or before any court established in the Federation of Nigeria. According to that section, it simply means that the Act shall apply to all those judicial proceedings before any court established in the Federation of Nigeria. What then are those courts that are established in the Federation of Nigeria? The answer to that question lies in Section 6, subsection 5A to I of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Such courts may be the Supreme Court, the Court of Appeal, the Federal High Court, and other courts established by that Constitution. The Act, Section 256, also provides that the Evidence Act 2011 shall not apply to proceedings before an arbitrator. A field general court martial, customary court of appeal, area court, or customary court. So the Evidence Act does not apply to proceedings before these courts. Arbitrator, a field general court martial, civil proceedings before Sharia Court of Appeal or customary court of appeal, area court or customary court. Nevertheless, that section 256 provides that for the Evidence Act to apply to proceedings before the Sharia Court of Appeal, customary court of appeal, area court or customary court, and an authority empowered to do so under the Constitution by an order published in the Gazette must have conferred such authority on the Sharia Court of Appeal, the customary court of appeal, area court or customary court. In other words, it is only when such authority is conferred or power is conferred on those courts that the Evidence Act 2011 can apply. You're also expected to look at section 2562 and 3, section 2 and 3 of the Evidence Act 2011 as regards to criminal proceedings before area courts. In the next slide, you will be expected to provide an answer to a class activity. Discuss the scope of the Evidence Act 2011. In today's lecture, we've looked at the sources of the Nigerian law of evidence. We've looked at the Evidence Ordinance of 1943. We've looked at the present Evidence Act of 2011, which is the current law regulating evidence in Nigeria. We've looked at also the application of the Evidence Act, the courts to which that act applies, and the courts to which it does not apply. I hope you have found today's lecture interesting. Thank you.